Welcome, everyone, to this explainer. If you're a law student, a legal professional, or honestly, just someone fascinated by how the highest courts in the land dissect human intent and family drama, you are in the exact right place. Okay, let's dive right into this. Today, we're unpacking an absolute masterclass from the Supreme Court of India, the 2020 case of Kavita Kanwar versus Pamela Mehta. Now, this isn't just some dry procedural ruling. Oh no, this is a high-stakes clash over a highly valuable defense colony bungalow in Delhi, and it's all wrapped up in a deeply complex testamentary mystery. We're going to break down exactly how the Supreme Court evaluates the true validity of a will when the paperwork looks totally perfect on the surface, but the circumstances beneath are, well, completely tangled. So get your notebooks ready. Here is our IRAC-style roadmap for today. We'll hit 1, the lopsided will, 2, the legal rules, 3, a battle of arguments, 4, the court of conscience, and finally, number 5, the final judgment. All right, starting with Section 1, the lopsided will, which is really the inciting incident here. So picture this. The inciting incident revolves around the estate of the late Mrs. Almar Carr. She passed away, leaving behind a son and 2 daughters. In 2003, her daughter Kavita stepped forward seeking probate for a will dated back to 1994. But almost immediately, legal alarm bells started ringing. You see, the mother's primary asset was this highly valuable bungalow in Delhi's defense colony. Under this specific will, that asset was bequeathed almost entirely to just Kavita. The other daughter, Pamela, received only a tiny fraction. And the son? He was completely disinherited. 0%. And this brilliantly illustrates the problem. This highly unnatural distribution prompted Pamela and the son to contest the will, kicking off a massive legal battle that went all the way up to the Supreme Court. Which brings us to the absolute core of the matter, the precise legal issue the Supreme Court had to resolve. Was the will a valid testamentary document executed by the testatrix, the mother, in a sound and disposing state of mind? Or, despite the formal execution requirements appearing to be technically met, was it invalidated by suspicious circumstances? For those of you taking notes, make sure you get this down, because this is the exact question of law. The court had to figure out if the shadows surrounding the document were dark enough to void the whole shebang. Moving right along to Section 2, the legal rules and the statutory framework. Now, the absolute centerpiece of this whole case is the doctrine of suspicious circumstances. This is such a vital legal principle. It basically dictates that merely proving a person's signature is at the bottom of a will, that's just not enough if there's a shroud of suspicion surrounding how that document actually came to be. If distrust exists, the burden falls heavily on the propounder, the person trying to enforce the will, to clear the air. They have to definitively prove that the execution of the will was a completely voluntary, uncoerced act. You'll see the foundational rules laid out here. Make sure you read through these statutes carefully for your notes. We've got Section 63 of the Indian Succession Act, which prescribes the strict rules for signing and attesting unprivileged wills. Then there's Section 68 of the Indian Evidence Act, dictating that at least one attesting witness has to testify to actually prove execution. But beyond these written statutes, the court relies on a standard developed through decades of case law. It's called the test of satisfaction of the conscience of the court. Essentially, the judge must be fundamentally ethically satisfied that the document represents the person's true intent. Let's get into Section 3. It's a real battle of arguments, propounder versus objector. Now, what's really interesting here is the perfect tension between technical compliance and equitable fairness. On one side, we have Kavita, the propounder. She argued that the will was technically flawless, right? It had verified signatures, it had confirming witnesses. She relied on a fundamental property right. A person has the absolute right to dispose of their property however they want. She argued that favoring one child isn't a legal ground to strike down a will, especially since she claimed to have a much closer relationship with her mom. But on the other side, Pamela, the objector, countered that the will was completely shrouded in mystery. Kavita took an incredibly active role in preparing this document that heavily benefited her, and the total disinheritance of the son totally contradicted the mother's known natural affections. Okay, Section 4, the court of conscience, and unraveling those red flags. The Supreme Court had to take an exhaustive look at the cumulative effect of all this evidence, rather than just isolated facts, and it led to this absolutely phenomenal quote from the judgment. The court does not sit as a mere mathematician checking signatures. It sits as a court of conscience. I love that. It brilliantly shifts the legal standard away from some mechanical tick-the-box verification and elevates it to a level of deep ethical scrutiny. The court's conscience absolutely must be satisfied. Let's see how this builds, because the court actually stacked up 3 major red flags that created an insurmountable wall for Kavita. Step 1, active participation. Kavita wasn't just hanging out in the room, she was instrumental in drafting and executing the document. And under Indian law, when the primary beneficiary organizes the will, the burden of proof becomes overwhelmingly heavy. Step 2, unnatural distribution. Look, disinheriting a child is legal, but doing so without a single word of explanation in the text? Massive red flag. And step 3, witness contradictions. When scrutinized, the attesting witnesses' testimonies actually conflicted regarding exactly where and when the document was even signed. But the real fatal blow, that came when the court looked at the mother's education level. The will itself was filled with complex, technical legal terminology. The court reasoned there was just no way Mrs. Amarkaur actually understood the language she was allegedly signing. And this led to a truly powerful conclusion. The mind of the testator does not go with the signature. Think about that. If the mind didn't grasp the words, the true intent was entirely absent regardless of whose ink was on the paper. Which leads us to our final section, Part 5, the final judgment and resolving the estate. So the crucial point is this. The Supreme Court ultimately dismissed Kavita's appeal and upheld the lower court's decisions. Probate was officially refused. The shroud of suspicion was simply too thick, and Kavita failed her heavy burden to clear it. Because the will was declared invalid, the mother's estate, including that highly valuable defense colony bungalow, was ordered to be distributed among all 3 children, according to the laws of intestate succession. By strictly applying the doctrine of suspicious circumstances, the court ensured a much more equitable outcome for the entire family.